Hey guys, Darrell Brooks has a sentencing hearing coming up. And I've heard some people say, well, what's the point of that? He was convicted of first-degree intentional homicide. That carries mandatory sentence of life imprisonment. There's no point to this. And that's not accurate. And I'll go over that. He gets a mandatory life sentence. That doesn't mean what you think it means, although the result could be the same after the sentencing hearing. What am I talking about? Well, his first-degree intentional homicides were Class A felonies, and in Wisconsin, that's a mandatory sentence of life imprisonment. So far, so good, right? And those type of sentences now are not eligible for parole. Case closed, right? It's not closed. You're dealing with lawyers, okay? The whole point of lawyers is to create new words and things like that. You need to know what a little thing called extended supervision is. That replaces parole for these kind of sentences. So if you think there's nothing for the judge to do because Brooks gets life without parole, you need to know that that's not correct. So yeah, there's no parole for these cases, but extended supervision is basically parole. In fact, let's listen to this judge who's dealing with sentencing in a case of multiple first-degree intentional homicides where the guy was found guilty, say basically the same thing. We call it extended supervision. I'm just going to keep calling it parole because it's basically what it is. Let's listen.
The determination of whether there should be any eligibility for parole in the future. Technically extended supervision, but it's easier just to say parole.
Now that case was the case of Chandler Halderson, another fine upstanding citizen of Wisconsin who murdered his parents, dismembered them, burned part of them, and then distributed body parts around the state. So a fine individual there. And he was convicted of 2 counts of first-degree intentional homicide, same charges that Brooks faced at his highest level. Yet he still had a sentencing hearing where it was possible for him to be eligible for extended supervision at a period of 20 years or after if the judge so decided. You get my drift why we have to have this sentencing hearing? We'll get into this again in a little more detail. So the judge has a responsibility to sentence on all counts. I know there's a lot of them, and in a cumulative fashion, he's never going to come out of prison, but it still doesn't go against the point that he's only been convicted. He hasn't been sentenced, and she has to make a sentence on each one of those. And there are certain legal requirements for that. The judges are not allowed to just do it. They have to have a record for that and something that could be reviewed on appeal, not in the Brooks case, but in other cases in case the judge is wrong. All right. So you have to follow the process regardless of the case. And that's what she's going to do here. It can also be the situation that some verdicts are upset on appeal. Maybe others aren't. So it's important to sentence all these things and to do it in the right fashion. So that's what we'll go over. We'll go over what happens in a sentencing hearing, especially one that involves multiple counts of intentional first-degree intentional homicide. The judge has to consider certain factors and certain information that relates to those factors and then make a decision on the record that involves some reasoning. That's the Court of Appeals standard. So let's get into that a little bit. So remember, again, as I said, Brooks is convicted, but he hasn't been sentenced. The jury's done. It's the judge's job now. And she gathers information and uses that to decide the sentence. And then she's going to state her reasons on the record. The normal rules of evidence won't apply in this situation. Brooks isn't going to be cross-examining the witnesses, and the state's not going to cross-examine people making statements for him. He may try and object and do things like that. He'll probably be kicked out of the room because this is not the time for him to be cross-examining or trying to poke holes into things. So there are 3 primary factors the judge has to juggle in her mind when she's deciding, particularly on these life sentences, whether he's ever going to be eligible for extended supervision or not. And that's the crime, the gravity of the crime. It's hard to think of one more serious than the one he committed, but the 2 examples I'm going to use throughout this video, one of them I mentioned is Halderson, where he murdered his parents in cold blood, dismembered them, burned them, and distributed their bodies. The other case is the Ivory case, where he murdered a woman and her 2 daughters and also burned them. So 2 victims in one case, at least 3 in the other. Same counts as Brooks is facing at his highest level. So I think they're instructive. They're both in Wisconsin, and they both had sentencing hearings. So the 3 factors are the crime, the gravity of the crime, how serious it is. Hard to be more serious than what he did. The character of the defendant and his rehabilitation needs. So that's where he'll be able to bring some people into the picture if he wants to. And also community and safety, right? That what's the impact on the community and the safety of the community depending on what sentence the judge hands down. And it's also appropriate to consider a punishment as well in this. But these are the three factors that they have to look at. Let's look at the video of the district attorney in the Halderson case, recognizing that the court needs to look at these factors.
Thinking about what the state's recommendation should be, with that being a foregone conclusion. Luckily, the law tells me what I'm supposed to think about when I'm considering what the executive branch of government is going to represent as its opinion in this case. It tells me that I should consider the gravity of the offense, the need to protect the public, and the rehabilitative needs of Mr. Halderson, amongst other factors, mitigating factors and things of that sort. But those are the three that generally are focused upon. They're called the galleon factors here in Wisconsin.
And here's the judge in the Ivory case where the guy murdered the woman and her two daughters in cold blood, also talking about that she has to consider these factors.
The court has to sentence every defendant with the minimum amount of custody or confinement consistent with the protection of the public, the gravity of the offense, and the rehabilitative needs of the defendant.
So to consider the factors, the judge needs certain information. I've seen this question a lot. Will the judge know his criminal history? And the answer to that is yes. Again, this is not a trial on guilt or innocence. This is consideration for sentencing, and the normal rules of evidence are out. The normal trial process is out. So there will be victim impact statements for things that are relevant to the sentence. The DA in the Brooks case has said, I think that they have maybe over 30 people that are going to testify. That can be done in writing. It can be done in person, and it can be done via Zoom. And the judge has said, I think that she's going to allow people to come via Zoom on both sides if they want to. The defendant will be able to have some witnesses too, to apparently, I suppose, to try and establish character or whatever. Same rules, live letter, Zoom. No cross exams. They're not going to be questioning these people. We're talking about leading questions and hearsay and things like that. These people will just be able to talk to the judge about what they want to say. The judge can also have a pre-sentence investigation done by an employee of the Department of Correction. So if somebody doesn't work for the DA, somebody who doesn't work for the defense, and that person, if they do it, will go out and collect information from both sides. The victims in the case will speak to the defendant if the defendant is willing to speak, find out about the defendant's background, the defendant's criminal history, aggravating factors about the defendant, any mitigating factors about the defendant or the case, and try and present to the court as complete a picture of everything that surrounds the case as this person can. The DA gets a copy of that, and the defendant gets a copy of it. The DA will argue on why they propose a certain sentence. In this case, they're going to want life with no chance for extended supervision, obviously. The defense will argue as well, Brooks in this case. I don't know how he's going to do that. It's a more sovereign nonsense, infringe on the flag, and he doesn't understand and things like that. I don't know. But the only relief he can have, being convicted as he is of a Class A felony that requires a life sentence, is to ask the court to allow him to have some kind of eligibility for extended supervision at some point. So the judge listens to that. And under Court of Appeals guidance, she has to consider this information and state on the record the things that will drive her decision as it relates to the sentence that's given. And in this case, for the life sentences, he could have a chance for extended supervision after 20 years or a later date if the judge were to decide, or never. Right? If she balances all the factors and says, due to the gravity of the crime, the character of this person, and the need for safety in the community, you're never coming out. And that's what happened in the Halderson case, where the judge said that the first time you will come back out of jail will be to be buried in a dignified burial, which was something you denied your victims. Pretty awesome statement by the judge there. Let's listen.
I have to, for this sentence, ensure that the only time Mr. Halderson comes back into the community is to have the privilege of a burial that he denied his parents.
But the judge doesn't just dunk on the defendant. They have to say these findings on the record. Let's listen to the example of that.
I cannot say to the community here in this room or at large in this county that Mr. Halderson should have the ability to be reviewed and considered for release back into our community at any point, despite his young age at this point in his life. The gravity of these offenses and the need to protect the public outweigh the potential that there could be that at some future point he should have presence among us.
And in the Halderson case, the judge then goes on to reference the statute, saying that I sentence you to no chance for extended supervision, although the little bit of audio at the end gets cut off. You can hear him diving down into the relevant statute. Let's hear that.
And so on counts 1 and 5, per statute, I sentence him to life in prison, and pursuant to section 973.014, sub 1G3, I find that he is not.
So the point of this video is a sentencing hearing is mandatory. The judge has a responsibility, right? And we all know Brooks is guilty and he deserves to go away forever. Everybody gets that. But not every case is so clear, and you don't have a special statute for Darrell Brooks. So he gets the process, right? He gets the process. The process requires the judge apply the law for the sentence, evaluate all the factors, consider the information, and then make a decision after weighing all those things and put it on the record. That's the judge's responsibility. That's what she's going to do. So in this, she's going to consider the information she's given, which is statements from victims, statements for character witnesses for Brooks, if he actually has any, other information that the parties want to bring out, and then she's going to make that decision. And then I have high confidence, like 100%, that her decision will be, you're never eligible to come out. You're never coming out of here, right? You're never coming out of here. Even though the judges have the discretion under a mandatory life sentence to allow that to occur, they're not going to exercise it in all likelihood in a heinous crime like this. I mean, it's just not going to happen. It's not going to happen. This guy, throughout the trial, created a perception that he was never sorry for what he did. At best, he was sorry he got caught. So there's nothing redeeming here to say, yeah, you should serve a bit of time and come out later, because he does not care about anyone but himself and no one's safety but his own. So he's going to go to jail forever. We're shortcutting to that when you just say, what's the point of the sentencing hearing? But that, I think, is going to be the result. It was the result in the Halderson case, even though that guy was every bit as evil, at least, as Brooks, because he planned that thing ahead of time to kill his parents like that. He still had the right to ask for the consideration of the possibility to come out later, and the judge weighed that, and the judge said it's not going to happen. In the Ivory case, where one of his stories was to defend himself, yeah, I killed them, but she ran at me with a knife and said, kill me and then kill these children. And amazingly, nobody bought that story. So he says he doesn't think about it anymore. He told the pre-sentence investigation person that, and the judge was not impressed by that. So she said, well, guess what? You're going to spend the rest of your life in jail. You're never coming out. You're not going to be eligible for any kind of release.
The court finds that the offenses that you've committed, based upon the entirety of the record that's before me and the observations that I have made in the proceedings that we've had today, does merit as to each count, and these counts will be concurrent to one another, but as to each count, your sentence will be life imprisonment. And the court has determined, based upon all of the factors that I stated, that you are not eligible for release to extended supervision.
So that's why they have the sentencing hearing. It's a requirement. There's a job to do. There is no mandatory statute that short circuits that. Life without parole isn't life without parole, because it can be with extended supervision. It's also possible she could have, an offender can be a persistent offender and also get life without any chance for extended supervision too. But I think in this case, it's just going to be under the normal statute for that. So I think that closes out the sentencing hearing thing. Will it be a 3-ring circus? Maybe, because that's how Brooks likes to live. Now, I wanted to go over a few issues that have been brought up in comments that I think are interesting and just cover those a little bit. And one of those, which has been persistent, which is his other pending cases off my last video. Why are they still doing those? Well, there is a good reason for that potentially, but first of all, who knows whether they will? While Brooks tried to make it sound like in his hearing for when they were going to set the sentencing hearing, that he was really busy with this other case and had something super important to do, his next appearance, as I stated in the other video, is just a final pretrial conference. It's not the trial. The trial's in December. So it's possible the DAs could watch the sentencing hearing, listen to it, see the results, and then say, well, we'll drop these cases. It's also possible Brooks could plead to those cases. Those two things are possible. But why would you keep the cases on? Well, besides the general interest of justice in prosecuting people for serious felonies they do, like shooting at people or running over people, another reason is just in the off chance, the slim chance that something happens to upset the verdict against Brooks in these murder cases, it would be nice to have concurrent convictions in another court that are also rock solid. Now, do I think the judge did anything wrong in her case and that he's ever going to get out on appeal for that? No, I don't think that. Just telling you that's the reason why they could do it. It's just as an insurance policy to make sure this guy never comes out again. So another thing that came up, which I thought was interesting, because I made a comment about responding to comments about bail bondsmen and how the whole system is just to make them rich. That's probably a consequence of the system, and I'm not arguing against that criticism or having good bail reform for appropriate cases. But it was pointed out to me, and I looked, and it said that there are no private bail bondsmen in Wisconsin, so that wasn't even an issue there anyway. So learned something there. That's a rare situation, but interesting. Another one that came up from earlier video is this issue of his competence to choose to represent himself, and therefore could he also have an appeal for ineffective assistance of counsel? And those are not the same things. Being found competent to choose whether you want to represent yourself or not is not the same thing as being competent in the sense of being good at or effective as being your own lawyer. So the Supreme Court has said, if you choose to represent yourself, you can't argue that you had ineffective assistance of counsel. That makes sense, right? Even if you're really bad at it. That's a different inquiry of whether you were competent to make the choice to do it or not. People choose to do things all the time that they're not good at or that they fail at. It doesn't mean that they should never have been allowed to make that choice. So the test for whether someone is competent enough to choose to represent themselves is a very limited test. Covered that over in the video. It's a separate issue of whether you can say you had ineffective assistance of counsel, because you can't do that. Once you cross that bridge, that you're okay to make that choice, and you make the choice and then you suck at it, it's your ball game then. Sorry. Final point is brought out to me by several people, which is my comment that Brooks was gaming the system by saying he didn't understand, or he didn't want to use the word understand, because understanding is a test of competence or some level of competence, that you got to know what's going on in order to be able to make these waivers and choices in some kind of intelligent, competent manner, right? So by saying he didn't understand, he would be undermining that, which I thought his way of doing it was completely ineffective. What I didn't know, and what people educated me on, was that refusing to say you understand something is more sovereign nonsense. It's something to do with you. If you say you understand, it means you stand under, and then somehow you're conceding authority to the court or whatever. And they profess to believe, and maybe do believe, that these magical incantations, if I don't say this, if I can see fringe on the flag, if I say this combination of words, I'm not subject to the jurisdiction of this criminal court. That doesn't work. It didn't work in his case. It's not going to work. Since he killed these people in cold blood, I guess he was trying to create a way where, in a world where he wouldn't be responsible for that, but it exists only in his own head. So that's it. If you have any comments, let me know. Otherwise, we'll see what happens on this sentencing hearing. The only other angle that was interesting to me was the lack of hate crimes charges in this case. I'm not going to go over that in this video, but that's also been the subject of a lot of comments, and I looked into that a little bit. So that's why we have a sentencing hearing, how it works, and what's probably going to happen at it. Is he gets locked up and the key thrown away. Thanks, bye.